Good morning, everyone. Welcome to the CCIPS CSIS 2016 Cybercrime Symposium. My name is Denise Jung. I'm a senior fellow here at CSIS and deputy director of our Strategic Technologies program. For the past several months, we've been working with the Computer Crime and Intellectual Property section of the Department of Justice to co-host this symposium. And we're very pleased that we've brought together 4 international panels on a range of topics, from the impact of various international frameworks for protecting expression and privacy and their impact on electronic evidence gathering across borders, to everyone's favorite debate, encryption and law enforcement access to data. We also have 2 incredible keynote speakers today, so without further delay, I'd like to introduce our first keynote speaker. Leslie Caldwell, Assistant Attorney General for the Criminal Division at the Department of Justice. As the head of the Criminal Division, Ms. Caldwell oversees nearly 600 attorneys who prosecute federal criminal cases across the country, help develop criminal law and formulate criminal enforcement policy. She also works closely with the nation's 93 U.S. attorneys in the investigation and prosecution of criminal matters in their districts. Ms. Caldwell has dedicated most of her professional career to handling federal criminal cases, both as a prosecutor and as a defense counsel. From 2002 to 2004, Ms. Caldwell served as the director of the Justice Department's Enron Task Force at the U.S. Attorney's Office for the Northern District of California. From 1999 to 2002, she served as the chief of the Criminal Division and the chief of the Securities Fraud Section. During her 11 years at the U.S. Attorney's Office for the Eastern District of New York, from 87 to 98, her positions included senior trial counsel for the Business and Securities Fraud Section, chief of the Violent Criminal Enterprises Section, and for her work on the Enron Task Force, Ms. Caldwell received the Attorney General's Award for Exceptional Service. She is also the recipient of the Attorney General's John Marshall Award for Trial of Litigation and the Attorney General's Award for Fraud Prevention. Prior to joining the Criminal Division, Ms. Caldwell was partner at Morgan, Lewis & Bockius. Please join me in welcoming Assistant Attorney General Leslie Caldwell.
Good morning, and thank you, Denise, for that very nice introduction, which unfortunately made me feel very old, hearing all those dates. But I really want to welcome everyone to the second annual Cybercrime Symposium. I want to thank the Center for Strategic and International Studies for organizing this event, along with the Computer Crime and Intellectual Property section of the department. I also want to acknowledge the presence of many distinguished participants today, including many of you who have traveled from around the country and around the world. As Denise said, the focus of this year's symposium is cooperation and electronic evidence gathering across borders. This focus is incredibly important to the Department of Justice, to the Criminal Division, because it really encompasses 2 very significant and related emerging challenges to our public safety and our national security. And those are the challenges that are posed when criminals use new technologies to victimize innocent people and to avoid accountability and, in many cases, even avoid identification. It also discusses the challenge that's posed when criminal schemes cross international borders, which they increasingly do. And legitimate law enforcement action to counter that international criminal activity it necessarily involves cooperation among law enforcement across borders. Addressing these 2 challenges are really 2 of the department's highest priorities. And frankly, from my perspective in the Criminal Division, these are 2 challenges that didn't really exist when I was in all those other jobs that Denise mentioned a few minutes ago, because crime was much more local, much less international, so the need for international cooperation was not nearly as great as it is today. For all of these, to address both of these challenges really requires us to balance several often competing goals and interests of multiple stakeholders. We have to protect the American people from threats to their public safety. We have to protect our national security. But at the same time, we have to protect privacy, and we have to protect freedom of expression, and we have to have cybersecurity. We also have to do our best to meet our obligations under our international treaties. And we also have to help other countries meet their public safety needs when they seek access to evidence, which is often stored in the United States. We have to be able to do that without putting our own American businesses in a very difficult and untenable position. So we're going to need to proceed very thoughtfully to balance all these multiple legitimate interests. But there are a few basic principles that we think should be obvious. First, sitting back and doing nothing as the world changes around us is not an option. It should not be an option. The world is changing. Those who seek to do harm to us, both on the national security front and the criminal front, and my focus today is on the criminal front, but everything I say could be equally applicable across the national security front. Those seeking to do harm are evolving as technology evolves. They are evolving their schemes, they are reshaping their strategies and their methods, and they're not going to stop doing that. So we have to adapt. If we don't have the same ability to adapt, if law enforcement doesn't have the same ability to adapt, public safety will suffer. Those changes also, they pose policy questions, and we need to have policy answers. Rather than let events or evolutions in technology and capability dictate our responses, we really have to think ahead as a society and develop an appropriate framework to address challenges before they become crises. And finally, we recognize that when there are multiple interests at stake, public safety, cybersecurity, international comity, civil rights, civil liberties, we can't allow these very consequential decisions, these most consequential decisions, to be made by any single stakeholder. Nor can we leave these decisions to the whim of the commercial marketplace. We would never accept that approach in any other area of importance to society, and we shouldn't do that here. And I'm going to get a water because I'm having allergies, and my throat is a bit dry, so excuse me. So I think this symposium is a really great venue to really take a step forward and, as Denise said earlier, really have a thoughtful discussion about these competing interests, bringing together a wide variety of perspectives so we can hear from different vantage points, including experts from the United States, foreign experts, academia, trade organizations, public policy groups. It's all very important that we all have this conversation along with government because we have these challenges. They're undeniable. They're right in front of us, and we have to work together to overcome them. There's absolutely no question that changes in technology have brought tremendous benefits to the global economy. With email, social networking, messaging platforms, and other innovations, we can do things that were unthinkable as recently as 3 or 4 years ago. Our daily lives are now online, and we're on network systems where we can communicate with people all over the world just at the press of a button. These innovations are connecting us globally, they're connecting us locally, they're connecting us with people we would never have been connected with before, and they're allowing our businesses to compete increasingly in global markets. So they're also allowing businesses from elsewhere to compete in our market. These advances have also transformed how we in law enforcement are doing our jobs. They've increased our ability to detect crime, to investigate crime, to prosecute crime. By using new technology, we can analyze evidence much more quickly than we did before. I remember when I was a young prosecutor going into rooms full of boxes of documents. And we don't have to do that anymore. I remember spending a month in a warehouse in Oklahoma, but that's a whole other story for another event. But really, by using these technologies, we can speed up our review of evidence, and we can speed up the accuracy of what we're doing, and we can better coordinate with our partners all over the world. Unfortunately, it's now becoming quite clear that these benefits also have a cost. And I don't think that cost was really widely appreciated until really fairly recently. But criminals are taking advantage of aspects of the internet to use it against us. So for example, criminals, and I'm not just talking about cyber criminals, we see this across every spectrum, from the street drug dealers to the most sophisticated international cyber criminals. Criminals are using the increased computing power, the widespread availability of high-speed internet. They're using virtual currencies. They're using the cover provided by technologies such as encryption and anonymizing software. And they're doing it, as I said, for every type of crime, to launder money, to sell drugs, to sell weapons, to exploit children. Criminals are also using that technology to invade our privacy. They're stealing our intellectual property. They're emptying our bank accounts of individuals and businesses all over the world. And cybercrime is particularly difficult because it's so international. Criminals are now able to use worldwide networks to commit crimes that previously could only be committed locally. So, for example, technology allows hackers to rob a bank halfway across the world. It also allows them to simultaneously attack multiple banks and empty millions and millions of dollars, whereas the typical bank robbery that you see on a street rarely nets more than $5,000 or so dollars. Technology allows hackers to steal personal information that's located in one country. It allows them to sell that personal information, that data, to criminals that are located in a second country, and then they can count their profits in a third country. Cyber criminals are sophisticated. They take advantages of weaknesses in computer security, but they also are sophisticated about the law. They take advantage, and we see this time and again. Criminals know which countries don't have robust extradition agreements or international cooperation with the United States, and they take advantage of that. They take advantages of differences in legal systems, hoping that investigators from a victim's country, such as the United States, which is the biggest victim of cybercrime in the world, they hope that investigators from the victim's country won't be able to get the evidence from the country where they are operating or where the information was sold or where the money was cashed. So as a result of that, international partnerships are increasingly vital to the fight against cybercrime. And we have terrific international partnerships in the cybercrime area. We also recognize that the development of encryption, and as Denise said, this is something that's been debated, and encryption is incredibly important. It's essential to counteracting cyber threats. It's essential to protecting our infrastructure, our intellectual property, our data. It's essential to protecting our safety, our privacy. Those are all extraordinarily important things, and we completely support encryption. But there are certain implementations of encryption that we cannot deny pose an undeniable and growing threat to our ability, to law enforcement's ability to protect the American public. In an attempt to market products and services as protective of privacy, personal privacy, and data security, companies increasingly are offering products with built-in technologies that preclude access to data without the consent of the user. For law enforcement, this has resulted in something that we refer to as warrant-proof encryption. That's not a technical term. It basically encompasses different types of technology, but it's really just used to describe a situation where a service provider has implemented encryption in such a way that it prevents the service provider from producing usable, unencrypted information to law enforcement, even in response to a court order. This is not a small problem. Some service providers with over 1 billion user accounts transmit tens of billions of messages per day around the world. Many of them now advertise themselves as unable to comply with warrants. And some device manufacturers have placed hundreds of millions of products in the market embracing that same principle. That's a very significant problem for law enforcement because back in those old days when I was an actual prosecutor doing cases, we relied on physical evidence. We relied on photographs, those boxes of documents, handwritten notes, documents filed in filing cabinets. That's all been replaced by digital evidence, by electronic evidence. In nearly every criminal investigation that we undertake at the federal level, and also, frankly, at the state and local level, whether it's a homicide, a kidnapping, drug trafficking, financial fraud, child exploitation, the critical evidence often comes from computers, smartphones, online communications. I think in pretty much every white-collar case that I've ever seen or done, the key evidence has been digital evidence. Email, text messages, chats. These materials are increasingly unavailable to law enforcement as a result of technology, even when we have a court-authorized warrant to inspect them. Our inability to get this data has, and will stop our investigations and our prosecutions in their tracks. And that in turn will increasingly pose a real threat to public safety as well as national security. Securing and keeping our electronically stored information private and secure is critically important, but so is the legal process that protects our values and protects our safety. These are complementary priorities. They are not competing priorities. Digital security is a vital tool, but it is not a cure-all, especially when it impedes our ability to protect ourselves and each other in the very real physical world. In fact, many of our currently most widely used network security products, such as malware scanning, simply wouldn't function in a world of universal warrant-proof encryption because they require access by somebody other than the end user to the contents of communications. We have to treat the implementation of strong encryption as a very important mechanism to manage risk, but only one of the tools at our disposal, and not adopt an absolutist view of its benefits or a disregard for its costs. The widespread adoption of default warrant-proof encryption really does affect real investigations, and I'll give you one pretty simple example, but there are many, many more examples like this. So, in 2015, Brittany Mills, who was 29 years old and pregnant, was shot in her Baton Rouge, Louisiana apartment. She died shortly after giving birth to her child. The child died 3 days later. Based on their investigation, this was a local investigation, not a federal case, the police believe that the clues to solving her murder most likely were on her phone, which was found in her apartment where she was killed. But because of the encryption technology used on that phone, it could not be unlocked without the assistance or consent of the very person whose murder the police were trying to solve. Because they can't unlock the phone, because they can't gain access to its contents, that investigation currently is at a dead end. That is just one of many, many examples, some much more complicated, which is why I chose a simple one. But this is something that we see time and again, and we're going to see more and more and more of. And there are also, another issue is that in many other situations, because investigators know that a particular provider might not be able to execute a court order because of their technology, their encryption, they don't even bother to seek the evidence. And that's something that we're seeing more and more of too. And this is not evidence that's something that's kind of icing on the cake that's nice to have on top of all the other evidence. This is often the evidence in the case. This is often the key evidence. So we're in the middle of a debate, as Denise mentioned, right now in the United States over how to handle these new technologies and the challenges that they create for law enforcement. And I'm confident that with folks like you putting your minds to this and thinking these things through and recognizing that there are several different legitimate interests here at stake, and they're all very important, I'm confident that we here in this country will figure out a way to navigate these issues while retaining our values. I'll close this part of my remarks by saying that basically the decision about whether law enforcement can access data has to be made in the policy arena. It can't be made by the private sector. I want to talk briefly about one other thing, because I see that we're coming up against the end of time. I want to talk about ways we've been addressing the international cross-border sharing of evidence. And as I said before, we're very engaged with our international partners on all sorts of operational matters. And we're engaged with partners who you might be surprised about. So, for example, Colombia, Croatia, Latvia, Nigeria, Serbia, countries that we haven't traditionally worked with on a lot of things, but that we've been working with a lot in the cyber area, as well as our more traditional partners from the EU and other places. So we've been working together in actual investigations, but we've also been devoting additional resources to helping gather evidence on behalf of our international partners. So a lot of evidence, as you all know, electronic data is stored in the United States. And there are many times when a foreign country may seek that evidence. In many instances, the law requires that country to submit a mutual legal assistance treaty request, which is a very formal process, which many of you are probably familiar with. These are handled by the Criminal Division's Office of International Affairs. The Office of International Affairs has seen a 1,000% increase in those requests in the last 15 years. So we're taking steps to increase our capacity to handle those things and to provide evidence to foreign partners in a more efficient and timely fashion. So we've created a cyber unit within our Office of International Affairs. They're focused exclusively on responding to and executing requests for electronic evidence from foreign countries. They work directly with their foreign counterparts to ensure that the requests are factually and legally sufficient under U.S. law so that we can get the evidence to them. We've gotten some additional funding to boost those efforts, and we're going to continue to work to increase those efforts so that we can provide timely and effective assistance to our partners. We've also worked with the State Department to work on multilateral frameworks for sharing evidence across borders. One of the things we've done is we've tried to get countries to sign on to the Budapest Convention, which is called the Convention on Cybercrime. And more countries are joining that convention. It requires countries, in order to be able to join, they have to have a certain level a basic level of domestic criminal law relating to computer law enforcement. A lot of countries don't have that. I was just in Argentina and Colombia last month, and they were both asking us, how can we have they don't have cybercrime laws of any real complexity, and they really need to work on that. And they both want to join the Budapest Convention, but they have to get up to snuff. So there are a lot of countries that want to join and will be joining. It's really recognized as the worldwide gold standard for addressing cybercrime, and so far there are 49 countries who have signed and who are members. One of the things that, if you're a member of the Budapest Convention, you have to also participate in the 24/7 high-tech crime points of contact network. That network has proved invaluable in a lot of investigations, both criminal investigations and national security investigations. In fact, in the recent international terrorist attacks in Europe, that network has provided invaluable assistance and has helped get data quickly and enable data access and sharing very quickly. Despite all the efforts that we're making in that area to share evidence, there still are obstacles. As I said, foreign governments often have to request electronic evidence from the United States that's located here, even in cases where the United States has no real tie to the case except for the fact that the data is located here. And under current U.S. law, there are certain obstacles to U.S. companies' compliance with those data requests. It may violate U.S. law for companies to comply with some data requests. So we're working to change that. We're working to change that legislation so that our companies won't have to worry about violating either U.S. law or disregarding a foreign court order and violating foreign law. So that's something we're working on. We're also working to guard against legislation that would erect new obstacles to our own ability to get access to data that's stored overseas by U.S. providers. Currently, we serve a subpoena or an order on a U.S. provider, and regardless where the data is located, we expect them to produce that data, even if it's on a server that's elsewhere. This is the subject of ongoing litigation, which some of you may well be familiar with. That's very important to us, and we don't want legislation that conditions our ability to get data on where the data is located. And so what we're doing, we think a more productive approach is to have a framework under which we can disclose data, our companies can disclose data to foreign countries directly without triggering a potential violation of law. We're working very hard on one agreement that would do that. That's with the UK. Those negotiations are ongoing, and we've been making a lot of progress. If the legislation to implement that agreement takes effect, if the agreement's signed, if that proves successful, we would hope that that would be a model for agreements that we could enter into with other countries. One thing that I really want to emphasize, for everything that we're doing in this area, and frankly in all other areas in the criminal division, we have maintained and are really focused on and committed to what has been our long-standing commitment to respecting privacy. In our cybercrime space, in our CCIPS section, a lot of what we do is guarding the privacy of all of you and of everyone in this country. We see some amazing, frightening invasions of privacy, and we are doing everything we can to try to stop those and to try to prevent those. we're also very, very committed to protecting everyone's constitutional rights and everyone's civil liberties. Concerns about privacy, concerns about civil liberty are fundamental to what we do at the Department of Justice. They're fundamental to our Constitution. They're fundamental to all the laws that we have on our books and that we follow and that our law enforcement partners follow every day. Those rules are respected and they're followed. And our commitment extends beyond just protecting the rights of the U.S. citizens. The President recently signed the Judicial Redress Act, which provides judicial redress to non-U.S. persons on a par with U.S. persons to rectify wrongful disclosure of data provided to the United States by designated countries. So in closing, we face a lot of very serious and complicated challenges in our ongoing fight against cybercrime, especially as it relates to electronic evidence gathering and as it relates to cross-border cooperation. The solutions to these problems, as I said before, are matters for public policymakers. Without a coherent set of policy decisions, we will be left in a world, we're increasingly getting there already, where technology will overtake our ability to protect the public and to assure justice. Finding these solutions is not easy. It's going to take a lot of hard work. It's going to take a lot of thought and a lot of smart people, including people like all of you. And we're going to have some difficult discussions about our competing interests. But I'm hoping that symposiums like this will keep that dialogue, will sharpen that dialogue, will focus that dialogue, and bring everyone together to discuss our diverse perspectives and to really make sure that we value privacy and encryption, but we also value our safety. Thank you very much.
Unfortunately, Assistant Attorney General Leslie Caldwell has an appointment right after this speech, so she's not going to be able to take Q&A today, but we do have a lineup of very interesting panels. I'd like to welcome our first panel up onto the stage. Betty?
Good morning. Okay, so you'll notice that this is not a deeply rehearsed panel since most of these people have never seen each other before. We have maybe 3 major topics to discuss with a number of subheads. We will try to include as much audience participation as we can. So the first topic is, for a long time, the world has been largely accustomed to having disparate standards of speech in different countries. If you didn't like a certain book, then you could stop it being shipped into your country at the docks. Speech is much more transmissible nowadays, so the first question really is, should there be one standard of freedom of expression to be used globally? And if yes, what would it be? And I think we will do this a little bit casually.
Can everybody hear me? Oh, good. The microphone works. Let me jump in and address that and say, in answer to the question, should there be one standard of free speech? Gosh, it would be great, but I don't think there's any realistic possibility of that. You know, on second thought, maybe it wouldn't be so great. Let's think about a non-speech example for a moment. I used to work at Visa, the payment card company, the U.S. law in the area of internet gambling is very interesting. We don't like internet gambling. Gambling is a sin. Internet gambling is even worse. So we don't allow it in the United States. And the payment card companies are forbidden by a 2005 law from processing transactions that involve illegal internet gambling. Now, that law could have been made international. It could have said, no internet gambling anywhere, and payment card companies enforce. In fact, what happened is the card companies devised a system whereby they would block the U.S. transactions and allow the transactions that were between or within countries that allowed internet gambling. Something like that has evolved in the area of speech. The payment card networks are all private networks. The internet is public. But a version of that kind of geographical segmentation has been worked out so that speech that's a violation of law in some countries can be banned effectively in those countries and permitted in the rest of the world. That may not be the ideal system, but given the differences that we have in our underlying views on what speech should be permitted and which speech should not be permitted, it may be the best way we can deal with the situation and still preserve international comedy.
Should the U.S. government be pushing for the dissemination of what the U.S. standard of speech? Emma, you wanted to.
Sure. Well, I just thought we should also kind of recognize we're not completely devoid of international standards for protection of freedom of expression, right? We have the International Human Rights Treaties. We have the articulation in the Universal Declaration of Human Rights that recognizes the right of all people to seek, receive, and impart information and ideas in, what is the rest of it? In media of their choosing, regardless of frontiers. That's not the exact wording. But we have, a set of standards that have been worked out, too, around what are legitimate restrictions by government on this right to freedom of expression. Governments have to establish that restrictions are necessary, that they're the least restrictive means to achieve a legitimate government aim, that they're proportionate to achieving that aim. So it's that we're not operating in a completely standardless sort of space here. We've got some basic principles that, of course, as we see different countries working them out, you end up with sometimes very different responses. For example, in the United States, we have, under the First Amendment, I think some of the strongest protections for freedom of expression anywhere in the world, and under our Constitution, we don't permit laws against hate speech. That's very different in a number of countries around the world, particularly in Europe. Some of our closest allies have laws prohibiting whether it's Holocaust denial or other forms of hate speech that would simply not be permissible in the U.S. So there is, for sure, some real kind of tension on certain issues, but we do have the fundamental framework.
Are the international standards navigable for speakers, for governments? Are they detailed enough, or is segmentation of speech a more practical response?
Good morning. For those who don't know me, I'm Bertrand LaChapelle. I'm the director of the Internet and Jurisdiction. Emma was mentioning the international framework, and it's extremely important to remember that in the Universal Declaration of Human Rights, there is this amazing articulation between Article 19 and Article 29. The general approach for all those issues is the affirmation of a very strong principle of freedom, and then a modifying paragraph regarding the potential limitations and the legitimate limitations for this. So it provides an international framework that has allowed, for better or worse, a diversity of implementation of those limitations, and I fully agree with the fact that there are elements of procedure, guarantees, proportionality, and all those things that distinguish national legislations regarding speech between the good ones and the bad ones. You may want to put the cursor in different places, but what is a common standard is on the procedural level regarding the capacity to have an independent judgment, to have a proportional measure, etc. That being said, to your question and to actually your two questions, a one single international standard on substance is not only likely to be unachievable, but probably, as was mentioned, not desirable. Because for anybody, it will be an alignment, for anybody in the US, it will be alignment on a lower standard, and for a lot of countries, whether we like it or not, it will be an alignment on a completely different standard than their own. So what is likely is that harmonization in that regard, and particularly on cross-border issues, which is the main problem that we have today, will go more on the procedural elements, like what are the procedures that you need to follow, what is the due process across borders that can handle requests for taking down one particular piece of content or not. A global standard on the substantive matter is extremely hard and, once again, difficult to achieve. On the question of whether the US should push internationally for the application of the standard on speech that is the First Amendment, I think the answer is pretty simple and straightforward. Advocate, promote, support, disseminate, yes, impose not. That's the bottom line. Think about it in the reverse manner. If that were the position that one particular country should be allowed or should be encouraged to impose through various means its own standards on others, there's no way to prevent other countries to want to impose their standards on yourself. So as we discussed during the preparation of this meeting, the expression that reciprocity is hell, always think about the, Betty mentioned that, always think when you try to iron out a general standard, how would that apply if somebody else were in a position of power to impose it on you? It needs to be like when you slice a pizza. You know, the person who cuts the pizza or the cake is not the person that distributes the portions.
Thanks. To pick up on the point that both Emma and Bertrand made, I think one very useful thing to focus on in thinking about the questions that you just posed is this idea that while it may be difficult or I guess a great fun thought exercise that we'll engage in as part of the discussion here to think about what a universal standard that would be, I guess, comprehensive to address speech and expression globally would look like, it is very important to keep in mind that we do have certain core fundamental principles around speech and expression that are enshrined in the Universal Declaration of Human Rights in Article 19, but also, very importantly, in the last few years, more than 80 countries, including the US and certainly all the, I would say, the leading democracies of the world in the UN, in the Human Rights Commission, have spearheaded several resolutions to make explicitly clear that those protections for speech and expression should apply online to the same extent that they apply in the traditional physical world. And for the US, the importance of focusing on certainly these core principles of freedom of expression and political rights is something that's captured in the President's 2011 U.S. International Strategy for Cyberspace as one of the most important core foundational principles for ensuring an open, interoperable, secure, and reliable Internet. And certainly the U.S. experience and the experience of many of our close like-minded partners is that there is a clear link, a clear causal link between freedom of expression, openness, free flow of information, and innovation, and particularly the type of innovation that has led to both the creation and the continued evolution and flourishing of the Internet and online activity. So that's part of the message that we spend a lot of effort conveying to international partners around the world. I will certainly say that some of the more challenging discussions I have as a diplomat in talking about the U.S. Approach to cyberspace policy is around this issue of speech. But what I try to often focus foreign officials on is not to immediately seize upon the areas of disagreement or the tensions, but to understand that there are great wide number of areas in which there is, I think, effectively strong international agreement, and especially when we're talking about criminal law enforcement. It's easy to identify certain areas of activity that one state may criminalize, the United States or another state may say that that's protected speech, but the reality is, and when we're talking about sort of core fundamental criminal activity, fraud, violent crime, drug trafficking, human trafficking, there's actually not a lot of disagreement, and these are not the kind of situations where we encounter inability to cooperate because of differing standards of speech. It's I think very important to keep in mind that our international cooperation with partners is not driven by these disagreements, but rather these are things that often lie, I think, much more on the margin of the discussions.
Emma?
And just to build on what Tom said about the kind of the connection between innovation and freedom of expression here, because I mean that's something that we see as crucial to kind of enabling people to really get all of the value that the internet represents. And I think that's because the internet as a technology, as a communications technology, trends toward enabling openness. It's a decentralized communications technology. It has low barriers to entry. Anybody with an internet connection could conceivably set up their own web page, set up their own email service, have a connection immediately to a global audience. It is a kind of technology that in its sort of initial state can really enable a huge amount of innovation and also this access to a platform for speech that the world has never really seen the like of before. And it's when you start seeing policies put in place to try to constrain that speech, to find ways to shut down the internet's ability to route around censorship, to shut down those avenues for communication, that you're really constraining just the sheer technical capabilities of the network. And I think that's where you see the kind of the constraints on innovation getting built in.
If I may, what is important, and this panel, of course, is not going to solve this question in an hour and 15 minutes. What is important in those exercises is to try to understand what are the different dynamic tensions and what are the competing interests that are at stake. I often say that there is a difficulty with the term balancing. When you say balancing different interests, it seems to imply, for those of you who are familiar with game theory, that it is a zero-sum game, like you have to give up something in exchange for something else. I very much prefer the expression reconcile. It's not always possible, but in many cases, the goal is to achieve all the goals together as much as possible. Sometimes the balancing in what you make a priority of is at stake, but reconciling different objectives is important. And here, one of the big challenges is introduced by the cross-border nature of the internet. Everything that was related to speech, when it was handled at the national level within national borders, was perfectly compatible with the Universal Declaration of Human Rights. Even with the disparity of legislations, whether we liked it or not, that was a fact. The problem with the platforms and the benefits of those platforms is that they are accessible everywhere and they're making global accessibility of content by default. This is a very important principle, that by default, this global accessibility should be preserved as much as possible, and only in certain cases should there be restrictions. But the key challenge is there is not such a thing as speech, period. There is a diversity of speech. And I can tell you that as a Frenchman or as a European, when you look at the jurisprudence on the First Amendment, it is far from being as clear-cut as people seem to imply when they travel around the world. It's an extremely sophisticated set of jurisprudence. And there are probably much less discrepancies starting from different perspectives in terms of what the law is. But it is also connected to the difference between civil law and common law. So we need to tone down a little bit of those absolute positions and look at the range of content that we're talking about. If you look at the international space, there are types of content that have reached a sort of universal recognition as being unacceptable. The obvious example is child abuse images. I don't think there is any country in the world, even the United States, that considers that child abuse images are protected speech and should be absolutely enforced worldwide. No, it's not true. At the other extreme of the range, you have things that are only considered really unacceptable in a certain number of countries. Insult to heads of state or blasphemy or things like that. Not every country has laws about it. In the middle, you have things like defamation, where the cursor varies in many countries. But there is a general understanding that, yes, libel and defamation is something that has to be taken into account because you want to protect victims. And so the big question is, you have a two-axis type of thing, which is the territorial impact, whether you allow it on some territories or not, and the types of content that are legitimately or possibly subject to restrictions. And here again, I want to come to the question of procedures. One of the key challenges, and we will address it probably later on, is that today it is not only a matter of discussion between states. It's a matter of discussion between states and private companies, because in many cases, it is the private companies that are hosting this content that are put in the situation of having to arbitrate whether some content is accessible or not.
And that's exactly where we are getting to now. But first I should say that I can't take credit for reciprocity is hell. That's somebody else's maxim. All right, so if we go on to the role of the private sector and reconciling, let's say, these diverse views about speech, the first question is, should providers have to carry all content, leave aside clearly criminal content? Should they have to carry all content? And if no, then who decides what providers have to carry? Does it make any difference if the providers are very large or if they have a very broad reach? Okay, that's about 5 questions.
It's only one, really. Should the platforms have to carry all content? I think the answer to that is clearly no. There was a time in the early days of the internet when people might have answered yes to that question. When people thought that the platform providers were like telephone companies, and all they needed to do was to connect people, and they had no more affirmative role in the managing of the content that appeared on their platforms. But over time, with the experience of large amounts of content, some of which was illegal, but much of which was not, but was sort of offensive and harmful in ways that didn't cross a legal boundary, almost all the intermediaries have now adopted terms of service that allow them to remove content that they find don't meet their own standards. And those standards vary in lots of different ways, from privacy and defamation to hate speech to incitement to violence to terrorist activity. And that, I think, is progress. It's the maturation of the socially responsible online platform. We want companies to be affirmatively responsible in that way. What should the role of the public be in that? To the extent that these companies are large and that their platforms become a kind of public forum for speech, the platforms owe the public a certain amount of transparency and accountability. What standards they use, how they apply them, need to be disclosed. There has to be a public conversation about that. There's a line, though, and the question is, to what extent should governments be a place of appeal in case some of these decisions that the intermediaries make are either too restrictive or too lenient? And here, I think the deference should be given to the platforms. Obviously, there are content that offends local law, and they should be able to tell intermediaries at that point, yes, take it down. But in general, the decision should remain with the platforms. Local governments should be in a position to enforce local law, and when the content does infringe on local law, there should be a process for them to be able to tell the intermediaries to take the content down. My own view is that that extent of jurisdiction extends solely to the jurisdiction of the country involved. It shouldn't cross borders. So, for example, and we'll have probably a longer discussion of this, our friends in France have recently decided that the right to be forgotten should be implemented globally, that the process of taking down search results and not reporting them should not be restricted just to European domains and European citizens, but if a particular search result is found to violate the privacy rights of European citizens, then, I don't know how to put this any other way, no one in the world should be allowed to get that search result, as opposed to no one in France or no one in Europe should be allowed to get that search result. That extension of the right to be forgotten to the globe, I think, is an example of overreach. It would be comparable to the United States saying, we don't like internet gambling, it shouldn't be allowed anywhere, and requiring our payment processors to take down internet gambling operations throughout the entire world.
We will definitely come back to the right to be forgotten in a few minutes. Emma?
It might be helpful, just for those of you in the room, if you're not familiar with kind of the legal framework supporting free speech in the U.S. We have the First Amendment that we've mentioned a few times, which is constrains what the government can do in terms of regulating speech, creating criminal or prohibitions or civil penalties for certain kinds of speech, which is fantastic and hugely important to all of us. But we also have, and I'd say equally important to free speech online, are protections from these intermediaries that Mark was discussing for legal liability, protections for the intermediaries from legal liability for speech that their users post. This law is called Section 230 of the Communications Act. It has two key parts. The first says that an intermediary, so whether that's your internet service provider, a content host, social media platform like Facebook or YouTube, domain name provider, those entities cannot be held legally responsible for speech that their users post. So if I tweet something defamatory about Mark can sue me, of course, but he can't sue Twitter, and he can't sue Comcast or Sprint or whoever else kind of enabled that communication. And that's, I mean, this is a pretty basic, and many of you are probably familiar with this, but we cannot overstate how important that kind of liability protection is to having a functioning internet. The US is not the only country by far that has these kinds of intermediary protections. We may have kind of the strongest form of them, but these are recognized at kind of the UN level as key protections for free speech online. And then we also, Section 230 also has a part that goes directly to Betty's question about what should companies be able to do in terms of setting terms on their standard. And so in the US, companies are protected under law to basically create and enforce their own terms of service. They are protected from suit from their users for actions that they take to take down to take down their user speech. They can police kind of violent or obscene or sexually suggestive or otherwise objectionable content. And so that is sort of the legal basis for all of the content policies that you may be familiar with on sites and services you use. And I think that's the right answer. I think there's one category of intermediaries we have right now that has this kind of common carriage obligation where you have, the intermediary has to carry all speech. That's our broadband internet access service providers. You may all have been hearing about the net neutrality debates over the past couple of years. Net neutrality is the kind of the policy question around, is there any intermediary kind of in the many layers of the internet that should be compelled to carry all user speech. Up at the content host layer, the applications, websites, or email providers law says no, you're not compelled to carry end user speech. But down at the very kind of fundamental layer of the internet, the transmission providers, the people who provide that last mile access between you and the global internet, when the FCC reclassified those carriers as Title II common carriers, they had essentially the same obligations that the telephone companies have always had to carry your speech, allow you to call whatever number, access whatever website you choose, and not put their own kind of determinations of what sites you should or shouldn't be accessing into play. So that's the structure that we're sort of starting from in the US, and to me I think that's a very good balance. I think we need to preserve a fundamental layer of neutral, kind of non-filtered, non-blocked access so that we can achieve all of the user empowerment benefits of the internet, so that we can ensure that this is a communications network that allows each of us to choose what is the information that we want to access, how do we want to publish our speech. But then the huge variety of sites and services that get built on top of that can each kind of develop their own policies and terms for the specific service that they're offering, and we as users have the ability to kind of choose among them.
Okay, so it sounds like we have agreement that providers, as private entities, regardless of their size or their reach, can enter into codes of conduct, can make their own decisions based on their terms of service about what content they will carry and what content they won't carry. Bertrand?
I think it's important to distinguish between a few different issues there. One is, as Emma was mentioning, the question that is the protection and responsibility of intermediaries. And here we are, again, exploring. You will find that this is almost a pattern or a methodology for the way I present things. It's always interesting to look at ranges and at scopes. We are exploring a range that moves from total non-liability and non-responsibility to complete editorial responsibility for news sites, for instance. You have a journal, something that is completely editorial, you have responsibility just like the traditional newspaper regime. In between, a lot of services have evolved. And the whole regime that has been extremely useful and is extremely useful for allowing the internet and the expression to flourish is fundamentally on the basis of the US regulation, of the e-commerce directive in Europe, to protect legitimately the intermediaries from the responsibility of the content that is posted by third-party users. So user-generated content, the companies legitimately shouldn't be responsible for that. At the same time, as was mentioned, it is true that in the course of the last few years, the situation of the major platforms has evolved from the traditional hosting companies where you just provided a server and somebody was putting his website on the server and you had absolutely no relationship with the content, to something where the terms of service have developed community rules and community guidelines. And so the first question is, what is the way to reconcile the question of the protection that is necessary to allow those intermediaries, and particularly the small ones, because we're always talking about the big ones that have the capacity to handle, they have the human resources, the legal resources, and the financial resources. But when you started a company and you are a couple of guys or guys and girls in a garage, proverbially, and you launch an app that has 20 million users in a couple of months, and you have a legal team that is basically half a person doing the contracts, you may be exposed to requests that are coming for takedown of content from all around the world. And so how you handle this is a very delicate question. You need to be protected, and at the same time, what is striking is that increasingly, governments are asking those companies to do a job of managing the content. And to the extent that the right to be the index that we will come to next, the highest court in Europe has explicitly entrusted a foreign private company to make determinations that are quasi-judiciary in balancing, this time, in balancing protection of privacy and interest to access to information. So when you think about it, the role of companies has evolved in a very strange way, where on the one hand, there is an element of protection. On the other hand, there is an incredible pressure on them to carry decisions, what somebody has labeled massive online micro-justice. Every single decision about taking down a tweet, taking down a picture, taking down a video is a micro-decision that has huge human rights and legal consequences. And so the key question is, how do we see this articulation between protection and responsibility of intermediaries in different spaces? What is the role of terms of service in that regard? Because to a large extent, it has become the law of the digital territories that span frontiers. And as was mentioned by Mark earlier, a key question is, what are the appeal mechanisms and the escalation processes across borders? I insist on the transnational element. Across borders. You have a court decision in one country, a request is being sent to a company in the US to take down a piece of content. This company checks whether it is in conformity with their terms of service or not. If somebody is not happy with this decision, where do they appeal? Which country? How do you apply this rule, and how do you establish jurisdictions across borders? That's one of the key challenge, and we're in a situation where there is a combination on establishing, on setting the norm, enforcing the norm, and adjudicating the norm that is actually becoming a shared responsibility.
I want to go on to talking about reporting to providers. But I wanted to warn the audience, I think we have time for maybe one or two questions at this point concerning the topics that we've talked about so far. So if the people with the microphones can be ready. But let me ask the next question first. There's now a practice, of course, that you can report to most providers content that you find objectionable. You can do this as an individual person. I think there's relative agreement that individual reporting is okay. The question I wanted to ask was, should governments be permitted to report to providers content that may be considered objectionable? What's the process? If they are asking, could not a demand to take content down, but a request to review content against terms of service. In particular, the focus here would be if it's a transnational request as a practical matter, what mechanism works transnationally? Emma.
Sorry, I'm so eager to answer this question. Because this is not at all a hypothetical question that Betty asks. It's a very important one that is actively being kind of enacted right now. Just this past week, we heard there was an announcement from the European Commission, the EU, and several major tech companies in the US that they had agreed to enter into a code of conduct around illegal online hate speech, and kind of the code of conduct lists out a number of different commitments that the companies are making, and that the European Commission and member states of the EU are planning to follow up on in terms of ensuring that when law enforcement in the different EU countries or people from civil society, from non-government organizations, or users send notifications to companies about the appearance of, the term they use, illegal hate speech, is found on their platforms, that material will be reviewed within 24 hours and the companies will decide, whether to take it down. Companies can decide under this code, first looking at their own terms of service, see if this speech kind of violates any of their existing terms against hate speech or threatening speech or harassing speech, and then may make reference to the laws of the member states. And
The reason I kind of describe this is because what is missing from this code of conduct is any kind of commitment from either the companies or the governments involved about transparency, accountability, or this question of appeal that Bertrand was raising. This is a kind of quasi-legal determination, an assessment that speech is illegal that manages not to appear to involve courts in any way. Traditionally, the way in a rule of law society that we apply laws prohibiting or restricting certain kinds of speech to a particular act of speech is to take that speech to an independent arbiter. It's not just law enforcement able to designate, what that person said violates the law, and so now they're going to be, the step is they get prosecuted, right? That question gets kind of assessed by an independent arbiter. Here, we have a system that's set up to have referrals from government, among others, to the companies asserting, alleging, just kind of declaring that speech is illegal, but without any of the procedural protections that we've been discussing built in. So the question is, it becomes, if I am a speaker, say I'm a German speaker, and I've posted something on Twitter, and the German government tells Twitter this is illegal, and Twitter takes my speech down. Nowhere in this process.
Excuse me, I think it's not whether the speech is illegal, but whether it violates terms of service. That's the more.
Well, so what that could be, right? That the kind of the traditional or the simpler sort of scenario is the German government or someone else wants to tell Twitter, the speech violates your terms of service. Even when it's even in that situation, I think when government is the one sending the kind of the notice to companies, we have this question of what's my recourse as the speaker against the government. But the thing about this code of conduct that was just announced last week is that it is entirely framed around being illegal hate speech. There's this assertion that this speech not only violates terms of service, but violates the law in these member states.
Right. So let me jump in, because I agree with you. The key thing in that agreement is that the platforms are being asked to assess not the legality of the speech. They're being asked to assess whether or not the speech is inappropriate under the terms of service that the companies had. And in principle, I don't have a problem with government drawing the attention of intermediaries to potential problems. President Obama did it in the case of the innocence of Muslims, and he said to the companies that were hosting the offending film, why don't you take a look and make sure that that really does live up to your terms of service? In fact, the company involved took a look and said, no, it actually passes our terms of service. They took it down in some jurisdictions where there were some legal issues or where it might be likely to incite violence. But the fact that President Obama said, take a look, is not in itself illegitimate. So I don't think in principle there's a problem here. In terms of appeal rights, the appeal rights that people have under the terms of service would continue to apply. The transparency of the judgment, the standards used, and so on would continue to apply. The only thing different would be the source of the complaint. Now, don't get me wrong, there could be problems here. If governments, and you can think of some examples around the world, were to set up teams of people to troll the internet and find people or organizations they didn't like, and systematically feed complaints into the platforms as a way of trying to bring that particular group of people down, that could be a problem depending on the kind of person that's involved. Some of these groups could be sort of evil hate speech terrorist groups, and some of them could be political activists who are simply on the other side of a political discussion from the governments who are complaining. So there could be problems here. I don't want to give it a clean bill of health, but in principle, there's nothing wrong with governments complaining in the same way that ordinary citizens are allowed to complain.
I think it's a couple things. I think it's a little easy in a free speech discussion for the discussion to become quite abstract and rarefied. And I wanted to drop a footnote here that, at least under US law, there's an enormous amount of speech that is absolutely protected constitutionally, and yet governments see causes a lot of human misery. You can all easily imagine individual scenarios of things that are posted that are destructive of private life, for example. Okay, suppose a provider says, I disagree with your view of what content should be carried on my platform, but I'll defend to the death your right to make that decision right after you buy the platform from me. And in the meantime, don't slam the door on your way out. You know, this is my decision. I'm a private entity. What's the response to that?
I think what is important is that we are witnessing a situation where the scale in terms of numbers of decisions is growing and extremely important. We're talking about thousands, tens of thousands, hundreds of thousands or more decisions that are very minute. And so one of the challenge of having everything going through courts is the overflowing potentially of courts. I want to make a precision here. As Internet and Jurisdiction, we are a policy network, so I have no particular position on those issues. What is at stake is to bring the different actors to understand what are the different dimensions. And here, one of the key challenges is that there is indeed an evolution at the moment that puts on private actors through their terms of service a role not only of adjudicating case-by-case issues, but also of de facto producing a form of harmonization across borders. Because those companies are in a very delicate situation. They are basically one decision away from a PR disaster each time, because they have accepted something they shouldn't have, or they didn't accept something they should have, and there was a murder afterwards or whatever. And so one of the key challenges is how to handle the discussion between those different actors. Because yes, there is a very big question of what is the basis for a request. And for instance, on the incentive for governments to ask the companies to take down content, not on the basis of their national law, but on the basis of terms of service, I can testify from the interactions that we have with a large number of governments in Europe, but also in Brazil and India and elsewhere, that they are torn. Because some of them are happily embarking in the bandwagon of saying, okay, I don't even have to prove anything in my national legal system, just use the terms of service and I'll be happy. And others are saying, wait a minute, I as a government, for my sovereignty, I'm not putting the decision-making in the hands of a company that may change its terms of service without my knowing. And so what has happened in the last few years, and we have witnessed it in the project for the last 5 years, is first a convergence de facto in the terms of service of most of the US companies towards accommodating a certain number of elements regarding hate speech, discrimination, etc. How far this should go is a very delicate question, because they companies themselves are comfortable trying to accommodate democratic countries in Europe and elsewhere. But the question is, how do they stop and where do they go? And then the next element is on the content of those terms of service, and I will finish with that, I always make a distinction between what I call the cat and dog rule, type of rule, and the public order rules. If you have a platform that basically is for cat lovers, it's perfectly okay to say there's only pictures of cats and no pictures of dogs. And if there's a dog and a cat, the cat can chase the dog, but not vice versa. That's okay. That's completely different from things that are related to public order matters of racism, xenophobia, anti-Semitism, and all those sort of things that touch upon what is the traditional attribute of states. And in that regard, what we need at the moment is a real discussion on what is the respective roles of the terms of service and the national legislation. How do you implement partial filtering or global filtering in some cases? What are the technical means? What are the procedural mechanisms for the interaction between the governments and the companies? What are the mechanisms for transparency on the types of requests? And more importantly, what are the mechanisms for appeal? So all these things are actually what should constitute a framework, a transnational framework for dealing with those issues, and this needs to be developed by the companies, the states, the civil society actors, international organizations, and the rest.
Okay, I lied to you all. We're not actually going to take questions right now because we're starting to run out of time. I know Emma wants to say something, but before you speak, let me add to the roster of things right here. If procedures are put in place by someone, a government, a multinational, a multi-stakeholder framework, then how could those procedures be made scalable, particularly in urgent cases? And then the corollary, Emma, you'll have about 90 seconds for all of this. The corollary is, doesn't a regime like that begin to look like governmental regulation of speech? Because otherwise, how is it enforceable? Okay, you're on.
Excellent questions. And just to underscore Bertrand's point about the importance of really thinking through what are all of the different what are the deeper questions that we're asking when we're looking at these, these ideas of, oh, well, should a government be able to push the flag button on YouTube or on Facebook? Because as we've discussed, companies can't, whether it's the cat dog kind of restriction or the counter harassment kind of restriction, companies can and do restrict much more speech than, certainly in the US, but in most democracies, than the law would permit government to restrict. And so if we are deciding, if we have this discussion and we decide under a framework that no, government should be able to flag material under terms of service, what we need to recognize is that we have just significantly expanded the kinds of speech, the amount of speech that government can seek to limit. That is a huge step, and it's one that we should make very thoughtfully and aware, or, maybe in my opinion, not at all, but it's one that we should not just sort of back into because the question of scale puts us at, it just kind of makes us throw up our hands and say we don't know what else to do. On the questions of, so what do we do? I think it would be useful to just quickly describe one current system that's in place. This is the way that U.S. providers deal with child sexual abuse imagery or child pornography. This is an interesting kind of system that is itself a bit constitutionally suspect. So the National Center for Missing and Exploited Children is a quasi-independent, quasi-governmental entity that receives reports from content hosts and access providers and other intermediaries about apparent child pornography. They maintain a database, and actually Microsoft has created a program called PhotoDNA that hashes, basically creates a digital fingerprint of the images in that database. And then these hashes, these fingerprints, are shared with content hosts and access providers in the US and I think around the world. They can compare the fingerprints of files that get uploaded to their services against the fingerprints in this database and see if they have a match. If they have a match, if they see that this user has just uploaded a file that pings something in the NCMEC database, they know someone's just tried to upload something that that NCMEC has identified as the kind of the worst of the worst child pornography. This is a system that's in wide use. It's on this kind of content that, as I think Bertrand was saying earlier, there's global sort of recognition that this is totally meritless as a kind of speech. We sort of legally consider it non-speech in the U.S. And it is a technically fairly effective kind of response because you are comparing novel images that your users upload to a reference database of things that have already been determined to be material hosts want to keep off of their services. This is it's a concern because the concern comes in because this database it's full of images that have not necessarily been determined by a court to violate any particular law against production of child pornography images, but it is something that's kind of in place and I think is considered to be pretty successful as a way to keep this the bulk of this material off of the bulk of sites.
Are you suggesting that that could be a model for objections to other kinds of speech?
I hope not.
Yeah, I would say no, because just the kind of the distinctions between assessing apparent child pornography as a kind of material that basically every country in the world can agree should be, kept off of the net versus, so kind of concerning extensions of this kind of program that we've heard proposed have had to do with terrorist content or terrorist propaganda. The idea that you might have some kind of much more subjective kind of content be treated in the same way starts to raise a lot of issues.
So then the question remains, would there be a suggestion about how those other kinds of potentially objectionable speech should be processed?
Well, let me jump in. I'm glad to hear that this unique case where you can use technology to identify the content is a unique case. It's not the general case. There's no way in when you're dealing with hate speech, terrorist activity, incitement to violence. There's no way that any of us know at this point. Now, maybe this will change in the future with AI and machine learning, which will replace all our jobs. But right now, it's so heavily context dependent. You cannot have the process automated. It's going to take large numbers of people looking at context and making judgments, perhaps fairly rapidly, that say, no, this thing is against our standards on terrorist activity. Now, I don't think, and I'm a great supporter of 230, by the way, just in case you might have missed that in my earlier comments. But the idea that the government shouldn't then step in and second guess that, I think, is crucial, right? Because then the activity of the intermediary really looks and feels like state action as opposed to private action. So 230 should limit that. But I do think that the intermediaries have to step in. They have to devote the time, energy, and resources to this. They cannot claim smallness or I'm just starting up or any of those other things that make for it's less of a concern if they've only got 12 users. But it's the kind of thing where if you're going to be in the business, you really do have to step up and take responsibility for this kind of stuff. The bigger guys have greater responsibility and they got the potential for causing greater harm, so they've got to do more. But I don't think there's any shortcut to this. There's no technological fix. There's no outsourcing it to government. I do think, by the way, just in the last point, I do think if there is going to be a government program to report content to intermediaries, it has to be a publicly disclosed program. It's got to be the kind of thing where people know about it, we have a chance to understand the standards that they're using, the intent that they have, and so on. It cannot be a secret program designed to undermine an unnamed adversary. So I do think there are dangers there that we need to be alert to. But in principle, I don't have a problem with the government being active in that area any more than any other person who might want to complain.
Okay, Tom, I think you wanted to address something, and then we're going to move on to the last topic so that we save some time for questions.
Thanks, Betty. No, I'd say one area that I think you'll see perhaps some innovative solutions coming up in terms of the whole issue of private sector and speech and government's role in reporting and helping identify and address it is the use of the internet for terrorist purposes. There's an enormous amount of activity, dialogue going on among the U.S. government and many of our key foreign partners with major providers, intermediaries located here in the United States and abroad, as well as with the advertising community and even Hollywood around how can we really develop the best, most robust, both technical and policy responses to deal with the increasing problem of ISIL and other terrorist groups leveraging social media to recruit, to spread their messages and the like. And there's actually a lot of activity going on, certainly for the United States government. This is, I think far and away the most important issue in this area that we are trying to tackle. And an incredible amount of receptivity also from industry partners, both here in the U.S. and abroad, about how we can effectively do this, because no social media company in the United States has any interest whatsoever in being seen or in allowing terrorist groups to leverage their networks for a wide range of purposes. The other thing I'd just like to make is just an observation, one that I frequently have in participating in or listening to these sorts of presentations, which are great fun to be part of, fantastic, very intelligent co-panelists and moderators and great discussions. But I would just make the observation that this is a very Washington or Brussels-centric discussion we're having here. I just came back from Bangladesh and Botswana and talked with very senior officials in the governments of those countries, as well as civil society and industry representatives about many of these issues. And the way in which the discussion is framed here, the assumptions that are inherent in so much of what we're discussing, certainly the sort of the legal and other frameworks that we're operating in, the discussion would go nothing like this in most of the rest of the world outside of the US and Europe and a few other very wealthy democratic countries. It's not that this conversation is not worth having in this context, or that this is not the right way to think about these issues from our perspective, but I would like to make the point that for most other parts of the world, having the discussion on these terms, just the concepts and the legal principles that we're talking about, would not get you very far in terms of trying to think about how to grapple with this. So many countries are looking at this at a much more fundamental and basic level. And while we think we have the solutions in terms of, okay, at a certain point you have a European or US legal system, you have these sort of very robust, sophisticated, mature industry sectors where you can have this kind of discussion. In much of the rest of the world, things are at a very different stage. And you really have to think about different ways to address these things. Certainly, when I'm sitting there talking with a Minister of Defense and Security or Justice in most of the rest of the world.
To follow up on that point, I think it does happen that speech that would be protected under U.S. constitutional law because it clearly would not cause violence in the U.S., sometimes, if it's posted from the U.S., in fact causes violence in another country. That's a conundrum. I wanted to go on to our last topic, which is the restrictions on speech in country A due to the actions of the government in country B. I originally conceived this as restrictions on American speech, that is, based on the UN Declaration, the right to speak and also the right to hear and see content. Because Americans are accustomed to a certain level of speech that is unusual for the rest of the world. So here is where we get to the right to be forgotten. And of course, the point here is it's not just American speech that is being affected by actions of different governments, but speech potentially throughout the world. So the first question is, and we've come to this a little bit so far, de-indexing globally as opposed to locally, is it always, never, sometimes justifiable? There are some cases where it has been ordered already. Comments?
One first thing that I want to say following what Tom was mentioning, it's absolutely true that there is a tendency, and I often find myself being the European representative in US panels, which is extremely interesting now. The interactions that we facilitate also in the context of internet and jurisdiction with Brazil, with India, and with other countries in Latin America or in Asia show that actually some portion of what we've been discussing actually fit. The whole portion about what is the substantive standard is extremely difficult unless there is a recognition from the onset that some criteria of territorial application of the national laws will be taken into account and that it's not going to be a global norm. But everything that is related to procedure has a huge resonance. And I can tell you that from my experience, every single interaction that we have with countries, be it the law enforcement or the ministries of justice in other countries, highlight that discussing concretely what the format for trans-border requests could be, what is the channel, what are the appeal mechanisms, what are the conditions under which this can be discussed, and whether the terms of service or the national laws are the basis, is a very operational approach that I think you probably heard as well, that can be a way forward. If we fight on the universal criteria, it's my law that should apply worldwide, which is the connection to Betty's question now, then you go nowhere. If it is about procedures, you have a chance of doing something. Now to the question of extraterritoriality. Yes, we have a big issue about extraterritoriality. And here again, I have no stakes in the particular decision. I just want to highlight that the right to be de-indexed, and please don't call it the right to be forgotten, but it's a precise thing. And the right to be de-indexed is a decision by the highest court in Europe. So in the US, you have an extreme respect for procedures and legitimately for court decisions. For Europeans, the fact that the highest court in Europe has decided that this right exists is a fact. The question of extraterritoriality is a very interesting challenge because I always remind my, my American friends that you may be much less familiar with a decision, not a decision actually, a case that was called Rora Directa and Bodog. Who knows about Rora Directa and Bodog? Okay. Very quick. Rora Directa is a site in Europe, in Spain actually, that was deemed legal under Spanish law, that was making links to videos and streaming videos of sports events. Entirely European. But because the website domain name was bought through a US-based registrar, in this case ENOM, the Homeland Security Department dealing with intellectual property has seized this domain because the content of a domain hosted outside of the US was illegal under US law. And the same thing applied for Bodog, which was a Canadian site, which was seized, the domain name was seized because it was in .com, which is a registry managed by VeriSign. So extraterritoriality doesn't apply only in one direction. And when you look at the question of the case that will necessarily come in the next panel about the Microsoft case and the data that is stored in Ireland, the key challenge is not in the abstract, again, whether extraterritoriality is good or not. It's how does a government exercise its sovereignty in the digital space when the application at the national level on an operator can have transboundary impacts. That's the key question, and it needs to be addressed because the right to be de-indexed is only one case, and it's particularly sensitive for Americans because it's one of the rare situations where you receive it. But this question of extraterritoriality is a really underlying issue regarding the transborder impact of national decisions.
Thank you. We have a few minutes for audience comments or questions. I think there are roving microphones. And if we get questions and comments, then I just ask the panelists to keep their responses very brief.
Thank you. Thank you. This question is primarily addressed to Bertrand. You mentioned the right to be forgotten ruling, and you state correctly that it's a ruling of the highest court in Europe, the Court of Justice of the EU. I put it to you that it's an appalling ruling. The Advocate General, when presenting the case, said, and I paraphrase, "Now guys, don't forget that Google is not the internet." And that's a mistake that we see taken at mid-level judges in this country and elsewhere. But the court, it seems to me, demonstrated that they have no understanding at all of how the internet works, and that they made a ruling against search engines, not just Google, of course, and expressed no interest at all in taking down the offending content, just the pointer to it. And they classified Google as a data controller, which I don't think they actually are. So I invite your comments on the validity, the goodness, if you like, of the ruling in that perspective.
Well, the answer will be very, very easy, because this is exactly what I was indicating at first I wouldn't do, because I respect the decision of the High Court. The problems that it raises now are sufficiently interesting and large to not try to revisit. And by the way, there will certainly be other court decisions that will come, because as you know, Google has filed a court procedure in the highest court in France against that very decision by the National Data Protection Authority. So we will be in a situation where the highest administrative court in France will have to make a decision on whether an independent authority, data protection authority in France, was right or not in requesting a global takedown. And it's a very tricky decision for all the lawyers who are in there. It is a very difficult decision. And I think we are now in a situation where there are more and more cases that are now bubbling up to highest courts in many different countries. And one of the challenges, they have to handle those decisions on the basis of very traditional, geographically based jurisdiction laws. And there is no reason to believe that those decisions are going to be coherent from one country to the next. So what we have labeled the legal arms race that is taking place right now extends to the courts, and there needs to be a better understanding of what are the challenges of extraterritoriality, because it can neither be for any decision just limited to the country, nor be global in all cases. So the question is, again, how to introduce nuance in this debate. I hope I answer a little bit.
Are there other questions or comments? Can we have a microphone here? Thank you.
Hi, Samira Daniels. I'm just curious, do you think that these issues are also in a broader framework, which we've been discussing in various other fora, which is about the militarization of foreign policy, for example, or militarization of space, and I'm wondering whether that broader query is going to elucidate some of the issues that you are presenting, because it seems to be the case that, because of national securitization of, and I think that James Lewis has made this point too, that we've securitized so much that, we're looking at these in this abstract, and it becomes even more abstract. So I was wondering if any of you can comment on that.
Well, I think we're absolutely seeing some of that dynamic play out in the kind of the question of what to do about terrorist propaganda that Tom was mentioning as well. Because, and going back to the kind of international human rights framework, one of the permissible or legitimate aims of government in restricting freedom of expression is to protect national security and public order. And so I think seeing that seeing national security justifications getting kind of brought into so many different conversations about these questions of how should government and companies relate around kind of the content that is hosted on those companies' servers, that's absolutely driving a lot of the debate. And I think actually this reminds me of something that, so Mark, several times you'd mentioned kind of this idea of, a government, kind of an official government program to go after companies' content under terms of service. And again, that's, as I think that's not a hypothetical. There are programs called Internet Referral Units in the UK and the Europol at the EU level that are explicitly these sorts of programs. And the kind of the procedures involved in there, and especially the lack of transparency, as Mark was talking about, I think raise serious concern, because we are not sure, we as citizens, we as people whose speech and whose access to information is being affected, do not know what are the standards that are being used, do not know what is the kind of scope of our government's efforts to see information and discussion and, yes, in some cases, pro-ISIS propaganda taken out of kind of the public sphere.
Okay, I think that was the last word. I'm sorry about the dearth of questions. You won't be surprised to know that we're not going to establish a conclusion from this panel. The next panel at today's symposium is on International Electronic Evidence Gathering 2025. And so we can welcome the panelists and the moderator for the next session now. Thank you all very much for your attention.